Okay, we're going to go ahead and get started with our second half. That was an excellent first presentation by Heidi. He really knows her stuff. You really do. You've got those documents. Not many people have those kind of documents. Okay. Glenn's going to talk to us some more about the amicus, where you can be a next friend and a friend of the court. So let's give Glenn a big hand for coming.
An amicus curiae. Okay, so I actually prepared one for Darren to file into a case. You need to open that up and plug it in. It's not plugged in. And oh, you do have it plugged in, but it still needs to be opened up. It's not opened up. It's not turned on.
Okay.
There you go. And start the recording. But anyways, I was going to do an amicus curiae, or the amicus curiae that I prepared for Darren to file into a case that we're helping someone on, or, and I'll let you guys decide, I was also thinking about, I sent Donald Trump a letter. And the interesting thing about that is that this is the first letter I sent to him. I sent it yesterday. It's in the mail yesterday. This is the first letter I sent to him in this presidency. But I can tell you that I sent in the first one, he had appointed, what's his name, that senator. Oh man, I can't believe I'm forgetting things nowadays.
The senator that you appointed for
as Attorney General, the first one, that was
they resigned, or said he's going to not run.
he ultimately resigned because
He's from Florida. It's like
no, it wasn't Florida. Oh, it might have been.
Right?
No, it was the first Attorney General that Trump appointed. He was
first administration.
yeah.
Jeff Sessions.
Yeah, right. Yeah, it was Sessions. Anyways, so what happened is I filed a criminal complaint against Jeff Sessions. It was a 250-page document, and I sent that to Trump. And he come out and started bad-mouthing Jeff Sessions. I'm serious. And Sessions ultimately resigned, and then that's when he appointed Barr. Anyways, I also filed a criminal complaint against Kirstjen Nielsen. Okay, she was Trump's Secretary of Homeland Security. And he came out and started bad-mouthing Kirstjen Nielsen. And I think he's reading my stuff, I'm telling you. And she ultimately resigned. And he put someone else in there, and I can't remember what exactly, but I know she resigned. Anyways, I went and filed a nastygram. I sent him a copy of a nastygram I sent against the Bedford Chief of Police because so when I sent a nastygram, I laid the foundation first. I sent them a notice of demand, and the notice of demand is designed to take away their presumptions. And then I sent them a nastygram, and the first paragraph of the nastygram says, normally I say I accept your oath of office like I did in this document I sent to you previously, but you and I both know you have no intention of honoring your oath of office, so, and then I start using four-letter words, F your oath, you lying, perjuring, MFSOB, okay? And there's like 20 pages of that. The second paragraph says, if you or your pigs want a piece of me, just name a date, time, and location. I'll come armed. We'll settle it for once and for all, you lying, perjuring, MFSOB. And yes, yeah.
He's not bad.
I've seen his nastygram.
Anyways, and then the third paragraph says, I know you'll never take me up on that because you're cowards. The first thing you want to do is make sure I'm unarmed so I can't defend myself. You lying, perjuring, MFSOB. And there's like 20 pages of that, right? Anyways, I found out later, nobody said anything to me, but Darren knew the mayor of Bedford at that time.
I met with him.
He met with him. And the mayor told him that the Texas Commission on Law Enforcement had raided the Bedford Police Department and fired everybody in there except for 2 people, including the chief of police, and they couldn't use their own jail anymore. So I'm serious. I think Trump is reading this stuff. I think he's going to read this, and there's remote viewed Congress adjourning for the last time. Now, some people think that this Brunson case that's with the Supreme Court right now is gonna cause that. I don't know, but I would say that once you see what I'm sending Trump, I think it's what I'm sending him. I'm actually preparing a Rule 11 petition to the Supreme Court, but you don't know if they're going to accept it, and that's going to take a while to get it all done. So we'll see what happens there too. And I talk about it in here. So what I was going to do is read this letter. Yes.
Maybe I just can't put it in context of the Brunson case that you said might change things.
Right. Sorry?
What is that? Just a thumbnail.
Well, what they did was they brought a lawsuit in the federal courts over the fact that Congress, after the first election, they refused to investigate the corruption in the election, the foreign interference, and they have a duty to do that. And so they brought it against like 300 members of Congress. And they spent quite a bit of money on it. I mean, when you think of how much it costs you to effect service on 300 people. But so they brought it against 300 members of Congress for refusing to investigate the foreign interference in our election and approving. They didn't even, they refused to, like they had to, there was a motion on the floor to hold things up for 10 days, that's all it was, pending an investigation on this foreign interference, and they refused to do it. And so if they were doing due diligence, they should have done that. But anyway, so that was the issue that's at the Supreme Court. Now, in regards to that, since you mentioned that, the Supreme Court doesn't like to get mixed up in politics. I can tell you that for sure. And there's court cases that talk about it. I have a court case in here that talks about it. And 107 said that the clerks told him, it was either the clerks or he heard by rumors that the clerks heard Roberts in the Supreme Court screaming at the top of his lungs, "We cannot accept this case." That was, the clerks heard it in the Supreme Court. And so the Supreme Court has basically blown it off several times, and the Brunsons keep bringing it back. And so right now it's just sitting there, and they haven't had a conference on it and decided to do anything or move ahead with it. It's just sitting there. Anyways, so that's the Brunson case. Now what we'll do is we'll go through this letter that I sent to Donald Trump. I made it like it's not double spaced. I made it space and a half just to make it easier to read, and it's size 14 font too, to make it easier to read. Anyways, and this is standard that I put in here. Notice and demand by declaration. Private man acting as president, the United States of America, and subordinates and successors. But notice here, it's the United States of America and United States of America. That's true. There's two entities. Anyways, at least two. So it says, I absolutely love the work you're doing, and I've always loved it, as evidenced by my YouTube channel called Sovereign Living. In 2017, I did these two videos. And then recently I did another video, Go Trump Go. In my opinion, most law enforcement officers are just honest, hardworking people doing a difficult job, but there's always those who want to make a name for themselves by taking reprisals against the sovereign citizen terrorist, which is why I copied you into the Casa Grande Postmaster Notice and Demand recently. I sent a nastygram to the Casa Grande Postmaster because he sent the Postal Inspection Service after me, basically. So they screen these military police for low intelligence and a propensity for aggressive behavior. There's court cases about it, and I have never in my life breached the peace. But the military police breach the peace on a routine basis with their unlawful arrests, their kidnappings, and false imprisonments. That's why I send out the notice of demands to educate my public servants about the law and, if necessary, put them into estoppel. Because I've sent out literally thousands of them over the years by registered mail and spent tens of thousands of dollars of the fake money. But I've been out of work since 2015, as described herein, and not sent too many these days. You, Donald Trump, the private man acting as President of the United States of America and as President of United States of America, are noticed there's millions of Americans who love what you're doing and are helping you in whatever way they can, because there's been a communist insurgency active in America since World War II that was alluded to by Eisenhower and subsequently by Kennedy in his speech 7 days before his assassination, which is why Howard Hughes was hiding out all the time. But the real source of the enemy is the Vatican, as described herein. Barry Soetoro, a.k.a. Barack Obama, is the most recent communist in the White House, and his tool, Joe Biden. In the 1960s, two communists, Cloward and Pivens, outlined their strategy to overthrow our government with a three-step process. Number one, spend money like mad to destroy the dollar. Number two, to weaponize the justice system to make war on ordinary Americans like myself. And number three, open the borders to allow millions of foreigners into our country. And I'm not sure, and I am sure you have noticed Obama and Biden doing all three. And Patrick Byrne has published an excellent video called The Enemy Within, which outlines the election thefts that you were subjected to, which is an act of war. And the communist Chinese are implicated, the Cubans and the Venezuelans. I know about the 200 generals that asked you to run for president, and in my opinion, your job was to jerk the chain of the deep state types and get them to expose themselves, and you are really good at that. He is, isn't he? I remember seeing you on television and how you jerk their chain and then reel it in like it's fishing. I think you're going to have to call up the militia, which is more than the National Guard. If you read The Sword and Sovereignty, published by Edwin Vieira, in which he says it's every able-bodied man between the ages of 18 and 45. And I'm well over 45 years old, but I will gladly help any way I can, and already do it with my YouTube channel and with local meetings. Vieira also says that if we fail to call up the militia, we'll end up with a police state, and I think he's correct. And to a large degree, we have a police state, and it's probably going to get worse before it gets better. What we're dealing with is diabolical evil. This is literally a war of good versus evil, and we were all born for a time such as this. Donald Trump, President of the United States of America, and as President of United States of America, are noticed there's 4 organic laws: the Declaration of Independence, Articles of Confederation and Perpetual Union, and the Northwest Ordinance of 1787, and this Constitution of the United States of America. And all our current problems started in 1861, but to understand the kangaroo so-called courts you were subjected to completely, and why we will never see justice in those courts, we need to go much further back in time before the Magna Carta. First of all, I'm going to talk about the Pope and the Vatican, but that's not to say anything negative about people who happen to be Catholic. I have lots of wonderful friends who are Catholic, and that's not meant to say anything negative about people who happen to be Catholic.
You didn't put, the pimp in there?
He's coming.
Sorry?
He's getting to the pimp right now.
No, earlier you said the Pope. The pimp.
Yeah.
He's being respectful right now.
No, pimp.
I'm being nice.
You're being smart.
So Rome was the capital of a group of ecclesiastical city-states in Italy. And this is taken from the Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean. Between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast area, 17,822 square miles. Population in 1833 was 2.742 million. Capital is Rome with a population of 153,000. Government and elected monarchy, the Pope for the time being the absolute sovereign with a consulting assembly of cardinals. And the history of Italy, AD 1208, Cardinal Locarius is chosen Pope and takes the name of Innocent III. He receives allegiance from the prefect of Rome and requires homage from all in the ecclesiastical state. So it's an ecclesiastical state. And that's taken from the modern part of a universal history from the earliest account of time, compiled by Western Original Writers, volume 25. It's about a 40-volume set that I have. Pope Innocent III coerced King John to surrender the kingdoms of England and Ireland in 1213. This is taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of pope. And not long after this, by general excommunication of the king and people of several years, because they would not suffer an archbishop to be imposed upon them, King, it's just John, it doesn't say King John, that's why it's in square brackets, was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under a rent of 1,000 marks. And because King John gave the kingdoms of England and Ireland to the Pope's ecclesiastical estate and agreed to rent them back with the concessions to the Pope, 1213. And this is the concessions to the Pope. We will establish perpetual obligation and concession. We will establish that from the proper and special revenues of the aforesaid kingdoms for all the service and customs which we ought to render for them, saying that in all things the opinion of St. Peter, the Roman Church, shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks. 700 for the kingdom of England and 300 for the kingdom of Ireland. Which precipitated the Magna Carta. This is a Canadian case. The Magna Carta is not a unilateral act emanating solely from the spontaneous will of the king, as the charters of the predecessors of John. Neither is it a treaty, for we're not going to say it was concluded between two legitimate independent sovereignties, nor between two nations, nor is it a law. The barons do not appear in it as subjects, for they are free to their promise of fidelity, and the king, brought captive, placed before them, submitted to the conditions which the conquerors imposed upon him. Magna Carta is therefore a contract, but resembles a treaty concluded between two nations, in that one of the parties, in virtue of the law of war, can impose its will upon the other. And that's Perlman versus Pichet, an Attorney General of Canada, intervenant, reference habeas corpus. That's a Canadian case. 4 Dominion Law Reports is what that stands for, which is full of prohibitions against the non-judicial proceedings being carried out by the Pope's owned and operated Crown of England under the Pope's Roman law. So think about it. So it says in chapter 29, section 29, no freeman shall be taken or imprisoned or seized or outlawed or exiled in any way destroyed. No, we go upon him or sent upon him, but by the lawful judgment of his peers of the law of the land. Chapter 38, no bailiff for the future shall upon his own unsupported complaint put anyone to his law without credible witnesses brought for their purposes. To no one will we sell, to no one will we refuse or delay right or justice. So those are, and there's a whole bunch more. Those are just a few of the obvious ones. And the Pope's Roman law is also called canon law. It says civil law. The term civil law is generally applied by way of eminence to the civil or municipal law of the Roman Empire, without distinction as to time when the principles of such law was established or modified. In another sense, the civil law is that collection of laws comprised in the Institutes, the Code, the Digest of the Emperor Justinian, and the novel constitutions of himself and some of his successors. And that's taken from Bouvier's Law Dictionary, 1856 edition, volume 2, page 8. Law canon. The canon law is the body of Roman ecclesiastical law relative to such matters as that church either has or pretends to have the proper jurisdiction over. Okay, so it's all pretended. Okay, you got to understand that. And that's Bouvier's Law Dictionary, page 8. It's on the same page as this other site. This is Encyclopedia Britannica, or a New Dictionary of Arts and Sciences, 1771. Okay, so this is like 4 years before the Declaration of Independence. Volume 2, page 883. The civil or Roman and canon law though they are perhaps not deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. So this Encyclopedia Britannica was obviously published in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground that they were conformable to the civil or canon laws. Okay? So they're saying that civil and canon laws are the same thing. And a special statute was just necessary upon the Reformation to rescind some of their constitutions as were repugnant to the Protestant doctrine. So again, Scotland, remember, and England, they actually eventually threw off the Roman Church, or at least appeared to, okay? King Henry VIII is the one that did that. But did they really throw them off? I would say not, because the Vatican still owns the government. But the Roman continues to have great authority in all cases where it's not derogated by statute or custom, and where the genius of our law suffers is to apply to it. And the kingdoms of England and Ireland, and now the United Kingdom, thereby became owned by the Pope. And the Pope's tool passed the Sesquier Act of 1666. Think about it. That was owned and operated by the Pope. And it's even talked about in this Tomlin's Law Dictionary. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were deprived of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal PFEs, to the use of the religious houses, right? So that's usufruct. Thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in a nominal PFE. It was held by the courts of equity, then under the direction of the clergy. Yes, and they're still under the direction of the clergy. That's why they wear that black robe uniform. It's all Roman law. To be bound in conscience to account to assess the use for the rents and emoluments of the estate. Well, that's taxes. Think about it. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And a use is a type of a trust. And the Sesquier use is a fiction of law under the Pope's Roman law, invented by the Roman praetors under the pretense of doing equity. This is Bouvier's Law Dictionary, 1856 edition. Fictions of law. Fictions were invented. Let's do this. There we go. Fictions were invented by the Roman praetors who, not possessing the power to abrogate the law, were nevertheless willing to derogate it under the pretense of doing equity. Fiction is the resource of weakness, which in order to obtain its object assumes as a fact what is known to be contrary to truth. When the legislator desires to establish his object, he need not pay any commands. Fictions of law owe their origin to the legislative usurpations of the bench. So that's talking about legislative, right? Remember we talked about how bills of attainder? And fictions of law owe their origin to the legislative usurpations of the bench, which is why the founding fathers prohibited bills of attainder, because bills of attainder are legislative acts, thereby prohibiting fictions of law. Bill of attainder means legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group. Sounds like sovereign citizens or you, right? In such a way as to inflict punishment on them without a judicial trial. Bill of attainder is a special legislative act prescribing punishment without a trial. Bill of attainders are prohibited by the U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. Bill of Pains and Penalties. Bill of Pains and Penalties is a legislative act, though similar to a Bill of attainder, prescribes punishment less severe than capital punishment. So the Bill of attainder was capital punishment. Bill of Pains and Penalties is less severe, which refers back to municipal courts and the Pope's Roman law. When acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not only the state courts, but the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial court for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. And that's K.C. Davis, Administrative Law. And the Sesticate use, fiction of law, was brought into America with the Code of Law for the District of Columbia in 1901. The Sesticate use, the legal estate to be in the Sesticate use, which is right here is the site at 31 Stat 1432, which is codified as described in 31 CFR 363.6, because an entity includes the estate of a living person, such as an incompetent or a minor. That's why your affidavit of life is just absolutely brilliant. Entity means any owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a deceased, or the estate of a living person, such as an incompetent or a minor. And a minor can be an individual who's attained the age of 18 years but has not yet taken control of the securities in his or her minor account. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account, which puts you under the Commerce Clause, Article 1, Section 8, Clause 3, bringing the District of Columbia outside not exceeding 10 miles square, in Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as made by session of particular states and acceptance of Congress, become the seat of government of the United States, in violation of Article 1, Section 8, Clause 17. And Congress, through their plenary power nationally, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. This is National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And it talks about plenary power, right? Through their plenary power nationally. That's dictatorship. Because plenary power is a dictatorship under the Pope's Roman law. Plenary jurisdiction, the court's full and absolute power of the subject matter and the parties of the case. Plenary is full, complete, entire. That's Black's 8 and Black's 9th. Plenary is full, complete in the courts of admiralty and the English ecclesiastical courts. This ties in Roman law. Causes or suits in respect of a different course of proceeding, in which these are termed plenary or summary. Plenary are full and formal. Suits are those in which proceedings must be full and formal. The term summary is applied to those causes which proceedings are more succinct and less formal. So it's kangaroo court. Okay, it's Roman law. Bouvier's Law Dictionary, 3rd Revision, 8th edition, Volume 2. Plenary is a power, or plenary authority is a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus, and that's taken from Wikipedia, but this is confirmed by Legal Information Institute, which Wikipedia is not a very good source, but Legal Information Institute is Cornell Law School. That's very good. Complete power over a particular area with no limitations. This power is often used to describe the commerce power of Congress. Under the Commerce Clause, Congress is granted full power over interstate commerce. The court has found the states are not able to pass laws affecting interstate commerce without the permission of Congress. And a use is short for usufruct under the Pope's Roman law, which is a type of a trust. Those things which perish by capitis diminutio, a usufruct, and matters enforceable by a statutable action. And this is taken from the commentaries of Gaius and the Rules of Ulpium, translated with notes in 1874. Those things which perish by capitis diminutio are of which kind are a usufruct, an obligation on the part of freedmen contracted by oath, and matters enforceable by a statutable action, that are administrative in nature, which is synonymous with executive, to carry out legislative policies. And this is Point Props, Inc. versus Anderson. The words administrative is synonymous with the word executive. And then the word executive connotes of or pertains to administration, especially management, as by managing, conducting, and superintending the execution, application, conduct of persons or things. Administrative acts are those which are necessary to be done to carry out legislative policies.
Where is that at?
That was actually one of the cases that Vince gave me. Point Props, Inc. versus Anderson, Alabama court case. And administrative proceedings are dealing with the Pope's minor estate, 31 CFR 363.6, under the Pope's Roman law. Administrator, a person authorized to manage and distribute the estate of an intestate or a testator who has no executor. In English law, administrators are the officers of the ordinary appointed by him in pursuance of the statute. Their title authority is derived exclusively from the ecclesiastical judge, and by grants called letters of administration. Why do you think it's called the Trump administration? Because they're dealing with dead things. At first, the ordinary appointed administrator of the Statute of Westminster required the ordinary appointed next of kin in relations by blood of the deceased. That's Bouvier's Law Dictionary, 1883 edition, page 119, which brings in quasi-contracts under the Pope's Roman law. We're talking about quasi before. Assumpsit, in its origin, an action of tort. Assumpsit of suit transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported by an implied promise, and even upon a fictitious promise. Introduced as a special manifestation of the action of the case, it soon acquired the dignity of a distinct form of action, which superseded debts, these are commercial terms, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, competed with equity. Okay, now here's that word equity again. In the case of essentially equitable quasi-contracts going out of the principle of unjust enrichment. And that's the history of assumpsit, Black's Law Dictionary, 8th edition. Both in Roman and English law are certain obligations which are not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of the fictitious expansion of a sphere of contract to cover obligations which do not in reality fall within it. And that's Solomon on Jurisprudence, page 642, 9th edition, 1937, Sweet Maxwell Limited, England, which requires the Pope's minor estate fiction of law. Constructive quasi-contracts are based solely upon a legal fiction or fiction of law, which involves the penal codes. Penal action is an action on a penal statute, action for recovery of penalty given by statute, where an action is founded entirely upon a statute. The only object of it is to recover a penalty or forfeiture. Such an action is a penal action. A penal action is a civil suit for the recovery of a statutory forfeiture when inflicted as punishment. Heidi was talking about a civil act earlier. Such actions are civil actions on one hand, closely related to criminal prosecutions on the other, to actions for private injuries, which the party agreed may, by statute, recover punitive damages, with punishment that is pecuniary for non-compliance with an agreement. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture, to be forfeited for non-compliance with an agreement. The words forfeit and penalty are substantially synonymous, and a pecuniary cause is ecclesiastical. Pecuniary cause, such as arise under the form of withholding ecclesiastical dues. So if you don't pay them your 10%, then they come after you with a pecuniary charge. See what I'm saying? ecclesiastical dues of the doing or neglecting some act relating to the church whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he's entitled to institute a suit in the spiritual court. Such for action are the subtraction or withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy as pensions, mortuaries, composition, and the like. And that's Holthouse, a New Black Law Dictionary, 1850, page 299. But they're quoting Book 3 in Blackstone's commentaries. And you commuted Roger Stone's sentence. Penance is a punishment imposed by the crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied to pious uses, pious uses. What a joke that is, Called commuting. And that's actually cited from Book 3 of Institutes. That's Coke in the 1500s, and Book 4 of Institutes, and that's Jacob A. New Law Dictionary in the 1750 edition. Which means you paid off the Pope for Roger Stone's sentence, and all prisons are related to the Pope. Penitentiary has meant a penitent, an ordainer of penances, a place for penitence. Anderson's Law Dictionary, 1889 edition, page 764. Therefore, Roman law and everything that comes from it is a violation of the organic laws, including Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion. And this is what the War of Independence was fought over, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending the course of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and publish, and instead thereof to publish and order the use and exercise of the law of martial. That's why you can't mix your law. And for altering fundamentally the form of government established by charter, so we saw the misery to which such despotism would reduce us. And for altering fundamentally the form of government established by charters, talking about the Pope's Roman law dictatorship. And it's also talked about as the same reasons for the separation from the Pope's owned and operated tyrant in the organic law, the Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, which can only be talking about Roman law. And this is some stuff. It also talks about transporting us beyond seas to be tried for pretended offenses. Well, that sounds like the Sestica V Act of 1666 for imposing taxes on us without our consent. That's another Sestica V. For depriving us of many cases of benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, altering fundamentally the forms of our governments. He's advocated government here by declaring us out of his protection and waging war against us. This is all talking about Roman law. Because the crown of England and the kingdoms of England and Ireland were then and are still owned by the Pope. And this is, and not long after this, by general excommunication of the king, by general excommunication of the king and people of several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. The Papal States were annexed to the Kingdom of Italy in 1870, but it failed to change the nature of the Papal States being ecclesiastical states. And this is actually taken from Wikipedia. During and after the Revolution of 1848, sentiment on the peninsula grew for the establishment of a unified Italian kingdom. Southern Italy had not been united with Northern Italy since the early medieval period, being mostly under the rule of the Kingdom of Naples and the Kingdom of the Two Sicilies. Northern Italy in the early 19th century came under the domination of the Kingdom of Sardinia, which besides its namesake island also ruled the expansive Piedmont and Savoy regions along the French-Italian borderlands. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies And the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy. So 1870. So in 1861, the southern states walked out of Congress. Congress ceased to have a quorum and could not conduct business. So on the 15th of April, 1861, under executive authority, it calls Stat 1258, Executive Order Number 1. Lincoln ordered them to reconvene, and they've been operating under executive authority ever since. The Supreme Court ruled on something that Lincoln failed to like, and Lincoln sent troops to the U.S. Supreme Court, which resulted in Rule 45 of the Supreme Court rules. Process mandates, all process of this court issues in the name of the President of the United States, which means there's really no separation of powers, and there never has been. This is Luther versus Borden, 1849. This is what I was talking about earlier. The Supreme Court does not like to get mixed up in politics. When a state forms a constitution which is approved by Congress, it's stopped to deny its validity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. They don't want to get mixed up in politics. A good case in point, Obamacare. There were judges and courts that were coming out and saying it's unconstitutional. And Obama came out and railed against the courts. And when it got to the Supreme Court, they fell right into line, and Roberts proved it. There's really no Article 3 courts because they're all legislative courts. This is Balzac versus People of Puerto Rico. The United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign faculty granted under Article 4, Section 3, making all equal rules and regulations respecting the territory belonging to the United States. Working for Congress, so they're all legislative courts working for Congress under Article 4, Section 3, Clause 2. Congress shall have power to make to dispose of and make all equal rules and regulations respecting the territory or other property belonging to the United States. And even the Supreme Court is an inferior legislative court, because Article 1, Section 1 of the Constitution says all legislative powers granted shall be vested in Congress. Article 1, Section 10, Clause 9 says Congress shall have power to constitute tribunals inferior to the Supreme Court. And the Supreme Court of the United States was created legislatively by the Judiciary Act of 1792, which implies that the Supreme Court talked about in Article 1, Section 10, Clause 9 already existed. Or one Supreme Court, a common law court of the people, by the people, and for the people, and the one in the District of Columbia today is the legislative inferior court, which is consistent with the fact that it's populated by the Vatican's bar members, and when they meet, it's called a conclave. In 1871, a year after the papal ecclesiastical state was annexed into the Kingdom of Italy, Congress created a municipal corporation for the District of Columbia at 16 Stat 419, thereby bringing the Pope's ecclesiastical Roman law into America. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence. That rule of action which every particular nation, commonwealth, or city is established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. That's Black's Law Dictionary, revised 4th edition. During the Civil War, the Pope's tool, Queen Victoria, sided with the southern states, and Queen Victoria sent fleets of ships to attack Washington, D.C., and San Francisco, and the Russians sent fleets to block them from doing that. Yet today there's a statue of Abraham Lincoln in the Pope's owned and operated city of London, and the only reason I can think of is that Lincoln facilitated this appearance of a true Article 13 and Amendment, which prohibited bar members from holding any office of trust, requires an oath of office. And this is the 13th Amendment. If any citizen of the United States shall accept, claim, receive any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present pension, office, or emolument of any kind, whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them. Okay, so that means under them is the federal government, either of them is the state government.
Does that include airplanes?
Because Lincoln was a bar member and would not have been able to hold office with it in place, the bar is an acronym which stands for British Accredited Regency. Okay, Regency is the office or jurisdiction of a region or body of regents, a government or authority by regents, the period during which regents or a body of regents govern. A regent is a person who exercises ruling power in a kingdom during the minority or absence or the disability of the sovereign, which is domiciled in the Pope's owned and operated city of London. Inns of Court. These are certain private associations in the nature of collegiate houses located in London, invested with the exclusive privilege of calling men to the bar. Which also means the National Bar Foundation is a violation of the organic laws, including Article 1 and Amendment. Congress shall make no law respecting an establishment of religion. Municipal law is the same as Roman law and came from the ecclesiastical papal states. Municipal was originally confined to the laws of the Municipia, or dependent states, which is now the Vatican. And this is Encyclopedia Britannica, or the New Dictionary of Arts and Sciences, 1771, page 883, volume 2. Civil or municipal law is that which every sovereign kingdom or state has appropriated to itself. The appellation of municipal was originally confined to the laws of the Municipia, or dependent states. So that's where it comes from. And the ecclesiastical papal state is now the Vatican, and it continues to this day as evidenced by the Lateran Pact of 1929. The sovereignty and exclusive jurisdiction of over the Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. That's the Lateran Pact, Article 4, 1929. And recently, Pope Benedict resigned, and the rumor was that they had been implicated in some child sacrifice ritual, and that the Italian police were going to arrest him if he left the Vatican. One thing is certain, Benedict never left the Vatican, and eventually died there. And Congress 1871 Municipal Corporation, 16 Stat 419, is bringing the Roman law into America and is a violation of the organic laws, including Article 1 and Amendment. Congress shall make no law respecting an establishment of religion. At this point, the only solution, in my opinion, is to dissolve the 1871 corporation and reestablish the Republic, and everything done after 1861 is Roman law for the 1871 corporation. The Republic is still here. We just have to reestablish it. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. I have a Rule 11 petition for the Supreme Court I'm working on over these issues, but there's no guarantee they'll accept it. You, Donald Trump, the private man acting as President of the United States of America, are noticed that Obama and Biden were textbook tyrants, according to Aristotle. A tyrant who, in order to hold his power, suppresses every superiority, does away with good men, fired Admiral Rogers for exposing the illegal NSA spying, forbids education and light, controls every movement of the citizens, that's the Real ID Act, keeping them under a perpetual servitude, that's taxes, wants them to grow accustomed to baseness and cowardice, has his spies everywhere to listen to what is said in meetings, that's NSA surveillance, spreads dissension and calumny, government trolls on social media and mainstream media lies among the citizens and impoverishes them, taxes and Obamacare, and is obliged to make war in order to keep his subjects occupied and impose the permanent need of a chief. And John Locke defines tyranny as follows. Remember, this is what the Founding Fathers were reading. The exercise of power, tyranny is the exercise of power beyond right, which nobody can have a right to, and this is making use of the power anyone has in his hands, not for the good of those who are under it, but to his own private separate advantage. When the governor, however entitled, makes not the law but his will the rule, and his commands and actions are not directed to the preservation of the properties of the people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion, 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that, for wherever the power that's put in the hands for the government of the people and the preservation of their properties is applied to other ends, and to make use of, to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and Section 201. And you yourself were subjected to Obama and Biden's tyranny, which you've been very vociferous about, and rightly so, and corruption in the so-called court, is nothing new, because much oppression has been exercised through the channel of these courts on persons charged with trifling offenses within their jurisdiction. And this court's ecclesiastical, spiritual courts are those courts which are held by the king's authority and supreme governor of the church for matters which chiefly concern religion. And the laws and constitutions thereby the Church of England is governed are diverse and memorial customs, our own provincial constitutions, and the canons made in convocations, especially those in the year 1603. Much oppression having been exercised through the channels of these courts on persons charged with trifling offenses within their spiritual jurisdiction. That's Thomas Law Dictionary, 1835 edition, volume 1. You, Donald Trump, the private man, are noticed I'm the guy who sent you a book entitled Trump, a True American Patriot or Not. You sent me a nice thank you letter, which I shall always treasure. You, the private man, acting as President of the United States of America, are noticed that Will Livingston ratified the Constitution for New Jersey in 1787 as my fourth great uncle, which means I'm posterity. And we the people in the preamble to the Constitution of the United States, in order to secure a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. And I am entitled to right of blood, and no civil law can destroy right of blood, because all the laws of Congress and all the laws of Texas are civil laws. The right of blood and kindred cannot be destroyed by any civil law. That's a maxim of law, Bouvier's Law Dictionary, 1856 edition. And you are operating under a power which is derived from me as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. And that's Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for me to give anyone or their bar member handlers or any court any authority over me. And John Marshall, the Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for me to confer a sovereignty which will extend over me. This is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission, but does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. That's why you want to be at least a state national. I mean, you don't necessarily have to be a state citizen, but state national. I am exempt from any of their corporate statutes, codes, rules, regulations, etc., not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that's U.S. Supreme Court, 1907, Kawanakoa versus Polyblank. And in House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, calls the people of the United States sovereign citizens. Whereas 2 million young men and women each year reach the age of 21 years, it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Because of our self-governing republic, but Obama circulated numerous news releases stating that all sovereign citizens are terrorists, as found in the ABC News article entitled "Sovereign Citizens, Terrorist Assessment Warns of Rising Threat from Anti-Government Extremists" by James Thomas, 30th November 2015, and the news article on RT.com entitled Sovereign Citizens Seen Top Terrorist Threat by U.S. Law Enforcement, and by Brian Blanco on 5th of August 2014. Numerous other articles stating they intend to murder any terrorist, sovereign citizen or not, without a trial, without due process of law, and by Obama's and then Biden's order followers, as evidenced by the Sovereign Citizen Quick Reference, which was published by the Joint Terrorism Task Force and the Federal Bureau of Investigation Military Police, which is attached here too. On or about 5th of March 2011, Patrick J. Elko, Special Agent of the Federal Bureau of Investigation, and Conrad Rodriguez of the Texas Department of Public Safety Joint Terrorism Task Force visited me over 14 years ago, and at that time Rodriguez told me 3 times that I'm listed as sovereign in their hearsay computer system, as evidenced by the intelligence bulletin issued by the Texas Department of Public Safety as described herein. Also in 1873, the U.S. Supreme Court ruled that everybody and everything not privileged is sovereign. Carlisle versus United States. The rights of sovereignty extend to all persons and things not privileged that are within the territory. So I try to stay away from anything their military police might consider a privilege, but if I put a private plate on my automobile to screen for low intelligence military police operating under the Vatican's Roman law, will arrest me and murder me if I exercise my right to resist their unlawful arrest. But the truth of the matter is that I'm not anti-government, because I am the government. As we the people, and Obama and Biden are making war on the Republic, and the so-called war on terror is really a war on we the people, and anyone who thinks they have rights, which includes preppers, survivalists, believers in the Second Amendment, homeschoolers opposed to the tyranny and the so-called courts. I'm very much in favor of lawful constitutional government as contemplated by the Founding Fathers and as required by the organic laws of the United States of America. And I believe that the Constitution has inspired God, who went to a lot of trouble to make sure we had these rights. And to do anything and derogate these rights is an offense to God. There's a story about the Constitutional Convention that says when the doors were locked and nobody was allowed in, then somebody appeared and told the founders the importance of what they were doing. Like Patrick Byrne, I'm listed by the U.S. Department of Homeland Security as a threat because I sent the Montana Chief Administrator of the Highway Patrol a notice of demand, which I told him that I have a right to resist an unlawful arrest with lethal force if necessary, as evidenced by the Amistad, which was a slave ship where the people killed all of their captors except for one because they did not know how to sail, and they demanded that the one survivor take them back to Africa, where the Supreme Court dismissed the murder charges and ordered them to return to Africa with the following, and that's U.S. versus Schooner Amistad, 1841, U.S. Supreme Court. And then I talk about, I included some court citations. These principles apply to an officer attempting to make arrests who abuses his authority and transcends the bounds thereof by the use of unnecessary force and violence, as they do to a private individual who unlawfully uses force and violence. An illegal arrest is an assault and battery. The person so attempted to restrain his liberty has the same right to use force in defending himself as he would in repelling any other assault and battery. Every person has a right to resist an unlawful arrest. In such a case, the person attempting the arrest stands in the position of the wrongdoer and may be resisted by the use of force as in self-defense. One may come to the aid of another being unlawfully arrested, just as he may where one is being assaulted, molested, raped, or kidnapped. Thus, it is not an offense to liberate one from the unlawful custody of an officer, even though he may have submitted to such custody without resistance. Story affirmed the right of self-defense by persons held illegally. In his own writings, he admitted that a situation could arise. Story was one of the judges on the Supreme Court, by the way. A situation could arise with which the checks and balances principles cease to work and the various branches of government concurred in a gross usurpation. There would be no usual remedy by changing the law or passing an amendment to the Constitution should the oppressed party be a minority. Story concluded if there be any remedy at all is a remedy never provided for by human institutions. That was the ultimate right of all human beings to, in extreme cases, to resist oppression and to apply force against ruinous injustice. And that's from a mutiny on the Amistad By Howard Jones, 1987, an encounter reading the decision of the case by Justice Story, Joseph Story of the Supreme Court. And the proof of service shows that he received it on 14 June 2010. A true copy of the Michael Tooley, Chief Administrator, Montana Highway Patrol Notice of Demand is attached here too, together with proof of service, all of which is incorporated by reference in its entirety. And the Montana Chief Administrator of the Highway Patrol conspired with the Texas Department of Public Safety to issue an intelligence bulletin on September 7th of September 2010, saying that their minor estate with a picture of me is armed and dangerous. A true copy of which is attached here too, all of which is incorporated here in this in its entirety, thereby evidencing their intent that one of their screen for low intelligence hired thugs murder me and get away with it because I'm armed and dangerous. Then I started getting harassed and assaulted at airports and border crossing. On 7th of January 2011, at approximately 1 p.m. in the afternoon, the U.S. Border Patrol I-10 highway obstruction about 7 miles west of Sierra Blanca, Texas, unlawfully arrested, which is an assault, me with no probable cause of a crime and no warrants, by dragging me out of my vehicle into their offices for about a half an hour and then telling me I could leave. Now I travel back and forth to Arizona from Texas on I-40 to avoid the Border Patrol assaults. In 2013, I was flying home from Calgary, Canada, and U.S. Customs took so long that I missed my flight. There was one customs official who had worked with sovereign citizens in Washington State and was sympathetic and told me to do a FOIA request, which I did, which took 6 months for them to respond. But when they did, it was the Texas DPS intelligence bulletin and over 500 pages of notice and demands that I had served on public officials, expecting them to honor their oath of office. The first paragraph says, "I accept your oath of office." They even shared their information with their Five Eyes Alliance buddies, because in the fall of 2013, I was traveling to Alberta in communist Canada, and the Canada Border Police engaged in war crimes when they arrested me and kept me in their torture chamber for over 24 hours with no coat and a temperature of about 40 degrees before charging me with smuggling, because they broke into my 34-foot travel trailer and found some pepper spray and a high-capacity magazine. They held a show trial under the Vatican's Roman law and sold me into slavery for 82 days. He, the prisoner, has a consequence of his crime, not only forfeit his liberty, but all his personal rights, except those which the law and its humanity affords him. He is for the time being a slave of the state. And further engaged in war crimes like the communists like to do, to take reprisals against their political dissidents by putting them into mental institutions, because they ordered me to have a mental evaluation for 30 days. A true copy of the Canada Border Services Agency lookout notice that says I'm a sovereign citizen and armed and dangerous is attached here too, all of which is incorporated herein by reference in its entirety. The fake judge in this case got his quid pro quo by getting promoted to chief judge in the Provincial Court of Alberta for participating in war crimes against a sovereign citizen, or as the communists in Canada like to call it, a freeman on the land, because we can't have anyone that's free. Obama's U.S. consulate in Calgary in communist Canada even got in on the action in the spring of 2014. I went to get a U.S. passport and they decided to take a nice long lunch break. And when I was finished and went downstairs, the Calgary military police were waiting for me. And I know the U.S. consulate did it because the Calgary military police told me they got a phone call from the U.S. consulate. When I got back home after 82 days of slavery, Obama's Federal Aviation Administration and Department of Transportation conspired together to say I was a threat and revoked my airframe and power plant license in an effort to make sure I could not get a compensation for labor contract. A true copy of the notification of revocation is attached here too, all of which is incorporated herein by reference in its entirety. In July 2015, I got a contract with GKN Aerospace at Montgomery, Alabama, and after 6 weeks, they laid me off, and they were very vociferous to tell me they had nothing to do with my work performance, because they were very happy with my work performance, but their corporate office had ordered it. The GKN Aerospace head office is in the Vatican's owned and operated United Kingdom, another member of the Five Eyes Alliance, and I have not been able to get a compensation for labor contract since. Because I've not been able to get a compensation for a labor contract, my wife has gone to stay with relatives in Canada, and I cannot see her because the Canada Border Police will assault me at the border. And needless to say, she's very upset about the whole matter. She previously had a green card and gave it back and is not allowed to work, but they're converting a right into a privilege because at common law, the wife takes the nationality of the husband, which is further evidence of the Vatican's Roman law. This is a federal court case. It's, however, true that in all common law countries has always been consistently been held that the wife and minor children take the nationality of the husband and father. That's common law doctrine. I have 3 sons and 2 daughters, and they refuse to see me because they're worried about losing their security clearances because I'm a threat. I cannot even see my grandchildren. A true copy of my daughter's letter to me asks me to leave because her husband's afraid of losing his security clearance is attached here too, all of which is incorporated herein by reference in its entirety. A friend of mine, a friend in Texas, let me sleep on his couch for several years, and eventually he started to need money, so I started to pay rent. But I ruined his couch. Since I'm paying rent, he gave me a room with a bed to sleep in. The only money I make is helping YouTube people who need help in my YouTube channel, and that is strictly donations and selling a complete set of my YouTube videos and my book that I sent you a copy of. And that is a long ways away from the $10,000 to $20,000 a month I used to make doing aerospace engineering consulting. I filed a few lawsuits with the Vatican's bar members, and the Vatican's Roman law means they presume you're guilty and they're busy selling their justice. There is no justice that goes on in those so-called courts, and you know all about it. All courts are operating under Roman law, which works on presumption. It doesn't matter what you say or do, and I think you have some first-hand experience with that, and which is one reason why people love you so much. Obama and Biden's Alphabet Inc. and their owned and operated YouTube took my channel down twice, and when they do that, they send you an email with a link to respond, and both times I told them the same thing. I told them, you're engaged in multiple felonies, you're violating my rights under the color of law, you're conspiring to threaten, coerce, injure, intimidate me in the free exercise of my rights under the color of law. You're subjecting me to your Satanism with your fraud, deception, your sorceries by your pharmaceutical companies peddling their pharmaceuticals, and you're engaged in war crimes by taking reprisals against me for my political beliefs and with your forced medical experiment. I'm going to sue your asses off. All your executive officers and board of directors are personally liable in their private capacity. Don't think I don't know what to do because I've been to the U.S. Supreme Court 5 times. You're next. And I have a YouTube video about it. Within 15 minutes of my response, my channel was put back up, and they took down a bunch of videos, and the shadow banning and demonetization continued at least until you took office. And they remonetized the channel earlier this year. Over the years, I have filed criminal complaints against every member of Alphabet Inc., board of directors, and the FBI, with the FBI, and they did nothing in support of their targetedjustice.com website and agenda, because they refuse to do anything about any felonies against me, because they intend that I exercise my right to resist their thefts and assaults and kidnapping, so they'll have an excuse to murder me, just like they did the guy in Utah who had a homemade plate on his car in spring of 2014, and they killed him, and their chief of police swept it under the carpet. Because when I turn up dead, they get to pillage the fake money in the minor state treasury direct account under the Hague Convention concerning the international administration of estates of deceased persons, concluded 2nd of October 1973. And if I do turn up dead, this is my deathbed testimony. And I recently subjected the communist property tax thieves of the county of Montague in Texas, who were in the process of selling my land because of approximately $400 of extortion in support of their first plank of the Communist Manifesto, the abolition of property rights, and extorted from me $2,300 to stop their forced sale of my land. I filed 78 criminal complaints into the Texas 97th District Court and with the FBI, and they both refused to do anything about it in support of their targetedjustice.com agenda, because they refuse to do anything about any felonies against me, because they intend that I exercise my right to resist their thefts and assaults and kidnappings, so they'll have an excuse to murder me, and they can pillage the fake money in the minor state treasury direct account under the Hague Convention concerning the administration of estates and deceased persons, concluded 2nd of October 1973. And they'd be happy if I turned up dead anyways. And if I do turn up dead, this is my deathbed testimony, just like they did to the guy in Utah who made a homemade plate in his car in 2014. And about a year ago, and they killed him. I filed a lawsuit in the federal so-called court, Northern District of Texas, 4th Division. It became case number 424 CB 881. But the bought and paid for horse, Howard Ray and Reed O'Connor selling their justice let me set up the appeal to the 5th Circuit, which is trying to dismiss it because of their filing fee extortion. I filed dozens, if not hundreds, of criminal complaints for felonies like violating my rights under the color of law, conspiracy to threaten, coerce, injure, intimidate me in the free exercise of my rights under the color of law, subjecting me to satanic religious ceremony, involuntary servitude, enticement to slavery, peonage, and numerous other felonies, state and federal, with the federal as well as the 97th District Court of Texas into the Northern District of Texas Fort Worth Division, and they've been ignored. And the bought and paid for clerk mastering as judge in the Northern District of Texas, Hal R. Ray, unfiled them because of their targeted justice.com agenda to make sure that I get assaulted, kidnapped, falsely imprisoned as much as possible, because it makes them so much business for their so-called court, because they intend to exercise my right to resist their assaults, kidnappings, and murders with lethal force if necessary, so they can have an excuse to murder me like they did the guy in Utah who had a homemade plate on his car.
That's the third time you mentioned that.
That's right.
So,
It's called reiteration.
Three witnesses.
that's right. And their chief of police swept it under the carpet, because when I turn up dead, they get the pillars, the fake money, from the minor estate treasury direct account under the Hague Convention concerning the international administration of estates of deceased persons. And if I do turn up dead, this is my deathbed testimony. I'm not telling you all this because I want you to do anything for me in particular, to make you aware of what is happening and some of the reasons why it's happening, and that I'm not the only one this is happening to. And there are millions of people who absolutely love what you're doing and will gladly come to your aid and are already doing what they can. I think that once you get rid of the corruption, most of the problems will go away. I've been blessed in many ways. And you know what they say, if it doesn't kill you, it makes you stronger. So since I'm not working, I spend time learning how to break it off in their ass. I heard that there are hundreds of people killed by the military police every year. Maybe this can be turned over to the war crimes investigation if I had a point of contact, because I'm sure that they can all be tied to communist George Soros and Nazi Klaus Schwab and the communist interference with the elections. Once you get the so-called courts fixed, I'll try again. One thing I've learned, not just because they dismiss a case with prejudice means absolutely nothing, because I bring it again anyways. It is never over until you say it's over. And that's the end of it, basically. And then I attached all those documents. It was about that thick, the whole thing, yes.
So I have a few things. So I recently learned that the word TICE means contract. So just TICE or no TICE, just contract. I want to look up them more, but I think the man was correct on the word TICE. I wanted to ask if you would be willing. I'm trying to do this myself. You talked about the bar. Supposedly they were the ones that created the International Bar Association, but I have not been able to find any proof of that, but they are tied to the UN.
Well, they are.
And so...
Well, that goes back to the city of London, actually.
Yeah.
The UN does?
Well, the bar. Remember, I showed the ends of court.
Yeah. But now they're saying it's the IBA, which is the International Bar Association.
There's a bar treaty of 1947, okay, and that's not listed in the treaty collection, but there is a bar treaty of 1947, and there is a National Bar Foundation. It's in U.S. codes, okay, and every state has a bar foundation. So, and they claim immunity, okay. And the only way they can be claiming immunity is under the International Organization Immunities Act. You see what I'm saying?
Yeah.
And so that's basically, I mean, I sued the state bar and they were claiming immunity. And so they didn't say why. It's kind of interesting that they didn't say why. I should have brought it up. I didn't think of it at the time. But they do claim immunity. And that's the reason that because really the state bar is a subsidiary of the DC 1871 Corporation. It's all subsidiaries. You see what I'm saying?
Yeah. So would it be worth bringing up the argument about international law being in the courts instead of actually, under the civil law, international law, because then if they're under that immunity, then that's really what we're in. We're in the UN International Law Court.
Well, Heidi's right. It's a private bar what do you call it?
Guild.
Guild. Yeah, it's a private bar guild. Absolutely.
Where did you see that it's the bar regency, not registry? I need to find it.
Regency makes sense. There's a friend of mine in Canada that does a huge amount of research. He'll go and spend hours, days in law libraries, and he does a huge amount, and he's the one that came up with it, and it makes sense.
It does make sense.
Because they're acting as regents, and for the Pope, basically, he's supposed to be running the show, and he's not here, and he doesn't want anybody knowing that he's the one that's really running it. You see what I'm saying? So they're acting as regents.
Well, I think their immunity actually just comes from the fact that they're foreign agents. I mean, it's no different than you.
Yeah,
Right, foreign agents.
Yeah, they're foreign agents. So it'd be no different than you saying you're a state national and you have immunity in the federal.
yeah, but I don't think it's registry. I think it's regency, and they're acting as regents.
Yeah, that makes sense, but I've never seen either one of them proved up.
No.
So
You're right. I haven't either.
I did come up with the fact that they have a international license standard number, which goes to them being able to rule a humanitarian rights for the UN.
Yeah, well, it's all tied into the UN too, and that's the Vatican, okay? The International Monetary Fund. I mean, so think about this way, okay? Negotiable instrument law is part of Roman law, okay? So all these banks are tied to Roman law. And so the Vatican, remember, back in the old days, they had the Knights Templar, and they had to get permission from the Pope to charge interest, right? But they couldn't call it usury, that's why they call it interest. But that's where it all comes from. So if they're charging interest, it's Roman law. If it's a negotiable instrument, it's Roman law. It's all tied into Roman law. Matter of fact, I didn't bring up all the stuff that would be unconstitutional because of that, but the Bank Act, the Securities Act, there's a whole bunch of stuff that would be completely unconstitutional. I gotta hit the restroom, so I'll be back in a minute, okay?
I have one more. I have one more when you come back.
Is that document up on your website?
Sorry?
Is that document up on your website?
Real men can hold it, buddy.
Hey, Ned, just as a viewer, I looked it up after you said entice. So apparently it's like an archaic term and it's not used. I looked for the etymology, and that etymology means to lure or entrap. And, right, to entice. And it's usually based on fraud, undue influence, and misrepresentation. So if you say no entice, that means no trap and fraud. So when we're giving notice, no trap, no fraud, right?
Okay.
And just entice, it's just entrapment, fraud.
Wow, so you're asking for entrapment, you want justice.
Yes, I want justice.
What a double, see, there's your double backward.
Oh my gosh, so the world we live in.
Yeah, I'll have to ask the guy that came up with that
Oh, yeah,
contract.
Yeah, I'd like to ask them, like, any association with contract, but it's just ChatGPT, what do they know? They only know what we
I guess what you put in there,
You know,
like you said.
I tried looking for,
I've been listening to all these people that have these conversations with ChatGPT and how dishonest it is, and I'm like, it's just like.
I think it's important to write a good prompt, like, when I'm doing serious work, you can write a good prompt.
Oh, yeah.
And, but,
I'm just saying, I'm just saying, I call it artificial idiot because, there's no such thing as an intelligence that's growing on its own. It can only aggregate things that it's been programmed to
that's
aggregate.
quite as stupid as the plan.
So,
Sorry.
exactly. Or by the most biased,
That's right.
I was putting that.
artificial idiot.
If you can't get your mother or a family member to do your life, not
I'm
proof of
working
life,
on,
but
I'm
proof of
working on
life.
that, so you know that when,
Did you use the Bible?
Yes.
Proof with your baptism?
So,
yes, like for me, if we have a family German Bible going back to the 1800s, that everybody in the family is documented.
Wow.
And so,
Well, I don't have that.
I mean, you can start it.
Yeah.
You know.
All right. Glenn,
okay, I'm back.
one more question.
What's that?
So, this is where we could make the argument of separation between church and state, right?
Absolutely. Well, that's the whole idea of the First Amendment. Congress shall make no law. Actually, our nation was considered to be a Christian nation. If you read the words in the Constitution, it's really talking about Christianity. But by the same token, Congress shall make no law respecting an establishment of religion, right? Your oaths, again, if you have an oath, then you have to be honorable. You see, I swear that I'll tell the truth. You see what I'm saying? And so it actually is tied in to Christianity big time. Common law. Matter of fact, there's that court case that I cite, Strauss versus Strauss, says that there's three systems of ethics, and common law is tied in heavily with our court system, and everything. Rules of equity are all tied into common law. But what happens is, remember, when you have martial law, it supersedes and replaces common law. So then the judges will even tell you, I can do anything I want in here.
That's correct. That's why that gold friend with the eagle on top says
Yeah.
do whatever we want.
That's right. That's why I got this. I got a common law passport from that common law website.
Prudent community?
Yeah,
You did that, okay.
yeah.
All right.
Hey, do you get into the weeds on when you referred to the Constitution in your letter, the of and for and little u and big U?
No, I don't. I mean, a lot of that stuff, it might be true, but it's a complicated argument, and you can't say. I mean, you got to be able to prove that stuff, and that's not an area I want to go to. It's easy enough to prove things with denials of due process of law and that kind of stuff. You see what I'm saying? And so that's easy because they do it all over the place, and so that's way easier just to go to do the easy stuff. I mean, trying to make those arguments, you'd be making 50-page documents, and they're not going to read a 50-page document. I can tell you right now.
I know, but I think where it matters, and I haven't fully dug into this, but I do think it matters. In fact, there's probably a video. If you guys have a group chat or whatever, you can post it. But it's the rights of a federal citizen, and it discusses really your only right as a federal citizen is to reside within the district. Right?
Yeah.
Which, and that can only happen if that's under the Constitution for that 10 square miles, which is different than the Constitution for we the people with the small u. Because the original Constitution, both in the handwritten copies and the draft, originally listed each state. We the people of New Hampshire, New York,
Right.
Pennsylvania, whatever. And so the small u was to be the adjective that described that group of 13 states at that time. And then the Constitution, and my mom would shoot me because she's an English teacher, and I should know the difference between of and for as propositions, which one belongs to which entity. But I do think it matters, and I think there is some loss of rights. And so when we're claiming that we're entitled to the Bill of Rights or any of these constitutional rights, I think we need to know which lane we're in.
You know what really made a difference when I was doing stuff is when I told them that Will Livingston's my fourth great uncle. And that means that I'm posterity is found in the preamble. And that's really what made the difference. So my mother did a bunch of genealogy, and I've got a fourth great grandmother. Her name is Livingston. So I'm just assuming Will Livingston's her brother because it's about the right time and everything. But again, prove that I'm wrong, and
I'm not. I'm just throwing it up as I mean, we read things, and one of them is, have you ever read the book or heard of it? It's by a guy named Lysander Spooner, The Constitution.
right, yep.
It just begs the question, where are we at? And what are we entitled to before we ask for it?
Well,
Because I don't want to get in a position where I'm asking for a privilege, because that's putting my feet right back into their
yeah, well, you stay away from the privileges, but the privileges, the driver's license, it's all about the evidence you give against yourself. That's why.
I kind of wonder, though, because the Constitution's a contract for us to assume the debt of this entity, right? That's what a constitutor is. If you look up a constitutor, that's the person who assumes responsibility for the debt. That's the definition of a constitutor. So if they're making the Constitution, and you're going to become one of the members of the We the People of the Constitution, I don't want to be a constitutor, a debt holder for that agency. So It's just something that, like, in my own digging, trying
Yeah.
to figure out, because that makes me want to stand back one layer farther under the Declaration of Independence and say, hey, I don't care about any of that bullshit. All I'm entitled to is life, liberty, and the pursuit of happiness. And the rest of you can be reformed because I think it's fine.
Well, they're very particular about following their rules, and the Constitution is the ultimate of their rules of what they're allowed to do and not allowed to do. And what they're doing is they're bringing the District of Columbia outside 10 miles square, and so that's why I use the Constitution. And I'm not accepting any debt. Matter of fact, the debt, if you read, the debt is actually fictitious, and it's unconstitutional. When you again, it goes to Congress shall make no law respecting the establishment of religion. Now, remote viewers have remote viewed Congress adjourning for the last time, and so I think that's going to happen. I don't think it's too far away. I don't know when or how it's going to happen. I'm hoping that maybe because of this letter that I sent Trump, that maybe they investigate that and they decide that that's what they have to do. I don't know. I wish I did. I don't have a crystal ball. But again,
I agree with you on, I think the Constitution and the reason you can play with them in statutory is because they are obligated by that document. But the flip side of that is, it doesn't have anything to do with me. It's for them.
you're right. You're right. It has absolutely nothing to do with you except that if
I'm not going to ask for rights under that because it has nothing to do with me.
it says in the preamble, it's to secure the blessings of liberty to ourselves and our posterity. And so then
It might be you because you're a blood relative, but what about everybody else in life?
all you have to do is say the words. How the burden's on them to prove it's not true. And
If I'm not, tell me I'm not.
I'm not saying that I'm not either. I'm just saying I don't know whether I want to be.
yeah, well, that's up to you. Everybody's got to pick their battles.
I mean, like I said, I just haven't seen enough evidence. I'm all about the evidence.
Yeah.
I've
So
been watching for so long, I can't take anything at face value.
well, they're nothing but a bunch of. There's ways of getting like what they did with you is you were retired from the military, so you're clearly in that system, and so there's ways of getting a remedy in any system. You just have to know how to do it, and you've come up with some brilliant stuff, but it's basically stuff that's brilliant if you happen to be in their system. The real solution is to not be in that system. In my opinion. But Ned, were you going to say something?
Well, I think Jason was first.
Oh, Jason, what?
I was gonna mention, you should have asked him like, hey, Mr. Trump, were you duped by the vax rollout and the warp speed, or am I supposed to trust the plan that traps?
Yeah, that the bioweapon was, it's not,
You know, the only thing I saw from Trump, I remember, in 2019 and stuff like that, in 2020 when they were talking about the jab, and the only thing I remember him saying was everybody that wants the jab is going to be able to get it. And so, I didn't want it from the beginning. I don't think he was duped. Matter of fact, he went and claimed to have had COVID, and he used hydroxychloroquine to get it cured.
He got the monoclonal antibodies,
Well, whatever.
which
But
they made illegal shortly after that.
well, that was Biden, though. That wasn't him. So I don't think, I disagree with you. I don't think he's part of it. I think he's fighting it. Remember, he's even said he wants to get rid of the IRS, and he's done stuff to get rid of it. He's gone to tariffs.
When that letter was really brilliant, it had a lot of great citations. Is that up on your website somewhere?
Sorry?
Is that up on your website? It had a bunch of great citations.
I can send you an email. Send me an email. I'll email it to you, the Word file, and then you can manipulate it however you want. Sure.
Yeah, it really was very well done.
Yeah, I can send me an email, and my website is sovereigntyinternational.fyi.
That's the one that's on your card, right?
Yes.
Okay, I'll do it.
And send me an email. I'll be glad to send it to you. I get a lot of emails, so tell me that, because I might not be able to tell from your email who you are. So tell me who you are. So, and yes.
I think, like what you just said, I'm kind of want to be careful what I say here because I'm doing ancestry research, and it was stated that the heritage.com and ancestry.com was sold by the Mormons.
Oh, really?
Yeah, and now the people that have it are actually selling your info. So, but their familysearch.org, which is free, they have protected and they are not sharing it with anybody. So if you know some of your info, you start putting it in there, and then it takes over and it tracks it from there.
Government program
What?
set up in the first place for people to willingly donate their DNA for the biometric police state that's coming about. We're watching it appear. Now we're cheering it on. All right. Same as DARPA Lifelog, which is Facebook. Hello.
But I'm not doing a
So-
DNA test. I'm
I'm just saying.
No,
Dude.
I-
I mean, I think y'all are crazy for doing that shit.
When I was
Now, if I commit a crime, they got my mom's freaking DNA. They got when they get this database together, they can tie me to a freaking crime just for my mom doing a freaking ancestry test.
I'm just saying, like you did of your posterity.
Yeah, your first 3 generations are private. Okay, after that is public. And my mother served on a genealogical mission for the church, and her job as a missionary was to go, and she was in Salt Lake City the whole time, and she would search these county recorder databases and search for the records, because all of the census records are in the county recorders in the various counties. And so she would search the census records, but it had to be more than 3 generations old, and come up with the people, because it says in I think it's in Revelation, it says the hearts of the fathers will be turned to the children, and the hearts of the children to their fathers. And so the Mormon Church thinks that they have to collect, the genealogy, and what they do is they go back to the king, because almost everybody eventually is connected to the king, and the kings, their genealogy is known. You see what I'm saying? And so all they do is they just have to get it back to a king or queen of England, or the monarchy somewhere, and that genealogy is all known, and so that's all they have to do, and so that's the reason they do that stuff. And so that's why Ancestry.com, once you fill in the first 2 or 3 generations, then they can a lot of times populate the rest, or at least. And what happens is there's other people, like you might have relatives that are interested in their ancestry, and so there's a lot of really interesting stuff. Like my mother found that there's a story in our family. My middle name's Winningham. My mother's maiden name was Winningham. Well, there's a story in our family about a guy in England, in the 1600s, that got these duels, and he would win the duels, which, think about it, when you win a duel, you kill the other guy, right? And so the other guys that he was getting these duels, their families were coming after him, wanting to get into duels, and he didn't want to get in these duels all the time. So he came to America and changed his name to Winningham. But Buckingham, his name was Buckingham. So maybe the queen is living in my house, eh? Or the king now. You see what I'm saying? But so the thing is that, so you don't know. There's some interesting history, family stories. I had a great grandfather. I don't know how far back, but there's a story about him where he lived to 99 years old, and the way he died is he got kicked in the head when he was shoeing a horse. Well, damn. I hope that's a good long stretch, and it was quick. What more can you ask for? You know what I mean?